an overview of criminal litigation. What is criminal litigation all about? To answer that question, we will attempt to define the term criminal litigation and the opposite term civil litigation. This will be followed by comparing and contrasting the two. Let's dive right in. What criminal litigation is all about. Criminal litigation is the procedural law governing court trials of accused persons, that is, criminal trials. Criminal law is a substantive law that defines crimes and punishments. Criminal litigation is the set of procedures for making, administering, and enforcing criminal law. Criminal litigation comprises the rules by which our courts hear and determine what happens in criminal proceedings, and this would include how the rules of evidence apply in trials of an accused person or accused persons. Civil litigation, on the other hand, is the procedural law governing court trials of persons who may have failed in their duties or rights or obligations towards another. That is, civil trials. Civil litigation, civil law is thus the substantive law that defines rights and responsibilities, while civil litigation is the set of processes for making, administering, and enforcing civil law. By the way, in common law legal systems such as Nigeria, all non-criminal law is civil law. Civil litigation therefore comprises the rules by which our courts hear and determine what happens in civil proceedings, where the rights, duties, and obligations of persons, be they natural or legal, amongst themselves, is alleged to have been trampled upon, denied, or breached, and should the court establish the same, the court may award the injured party compensation for the injury so established. Anyone can institute a civil suit. However, only a public official, known as a prosecutor, can institute a criminal trial against an individual alleged to have committed a crime or crimes. In doing so, the prosecutor is a representative of the government. It is the duty of the prosecutor to attempt to establish that the accused committed the alleged offense beyond all reasonable doubt, unlike in civil cases where the plaintiff needs a preponderance of evidence, that is, that on a balance of probabilities, the position of the plaintiff is more likely to be the true version of events than that of the defendant. In summary then, criminal litigation involves prosecution by the state or federal government of a defendant charged with a crime, while civil litigation involves matters between individuals, be they natural or legal, against each other for matters such as torts, contract disputes, fundamental human rights violations, to mention but a few. Criminal litigation is driven by the idea of punishment, while civil litigation is driven by the idea of correcting a wrong and or compensating the claimant for his loss. Let's go on to the scope of the criminal litigation course. This is just a highlight, not a deep dive. The range of issues that criminal litigation addresses, or this criminal litigation course addresses, include how to lay a complaint before a law enforcement agent such as the police, a police officer, how law enforcement should investigate a criminal complaint, how law enforcement should conduct searches of suspects, how law enforcement should conduct arrests of suspects, including who can arrest suspects, how law enforcement should interview a suspect, how law enforcement should institute criminal proceedings, how law enforcement should draft charges, conditions for granting bail to suspects pending trial, the constitutional safeguards to ensure fair trial of a defendant, how a criminal court should convict and sentence a defendant, how judges should deliver judgments, how convicted criminals can appeal verdicts that they consider unjust. Now that we are done building a bird's eye view of our criminal litigation course, let's do a deep dive by going through the entire curriculum. The first part of the course is entitled Introduction to Criminal Litigation, and we will treat an overview of the criminal litigation course, sources of the law and rules guiding criminal proceedings, types, settings of criminal courts. In part, we will treat jurisdiction and venue of courts of criminal jurisdiction. We will take jurisdiction separately and venue separately. We will apply these concepts to Nigerian courts, and we also apply it to the International Criminal Court. However, we will be concerned mainly with the jurisdiction of the International Criminal Court. We will address searches, arrests, and constitutional rights. And we will travel down such topics like authority for searches and arrests, execution of searches and arrests, admissibility of materials, procedure for challenging searches and arrests, constitutional safeguards relating to these procedures. Then, we will treat pre-trial investigation and police interviews, how police stations should conduct interviews, statement forms to be filled at the police station, and police bail, legal representation, and the rights of suspects at police stations. Issues in police investigation and admissibility such as alibi, confession, judges' rules, identity of suspects, expert opinion, and handling of exhibits. In part 5, we will deal with the institution of criminal proceedings. We'll consider authorities that can initiate the institution of criminal proceedings such as the Attorney General, the DPP, other officers, the police, other prosecuting authorities such as Customs, ICPC, EFCC, SSS or TSS, as well as private persons. We'll consider the mode and scope of institution of criminal proceedings by looking at information, charge, and complaints. In part 6, we will take a look at charges, the forms, the contents, the rules of drafting charges, amendment of charges, procedure after amendment, sample charges, and there will be a practical exercise involving the drafting of charges. You'll look at bail pending trial, the types, the scope, the consequences of bail, the procedure for application, and there'll be a practical exercise involving the drafting of motions, summons, and affidavits. In Part 8, you will pay attention to constitutional safeguards to ensure fair trial of an accused person. You will treat such rights as the right to counsel, the right to silence, access to defendant in custody, information of the crime alleged to have been committed, the provision of an interpreter, fair hearing versus the presumption of innocence, that offenses must be known to the law, the rule against double jeopardy, the right to examine witness called by the prosecution, right against trial upon retroactive legislation, right against trial for an offense for which the accused has already been pardoned. We will also take a look at trial. In fact, trial is such a major part of this course that it is broken into 4 parts. The first part is attendance of parties and arraignment. We will treat the presence of the accused, complainant, witnesses, and counsel in court, processes to compel the attendance of the accused, summons, arrests, and warrants, dispensing with the presence of the accused, as well as the presence of the complainant. We'll also take a look at the duties and roles of the registrar, counsel, and the judge in criminal trials, arraignment, recording of plea, options open to an accused upon arraignment. Trial. We will take a look at trial preparation, the rules of evidence as to burden and standard of proof, competence and compatibility of witnesses, how to develop a case theory or trial plan, subpoenas and witness summons, types, issues, and the use, how to prepare witnesses for trial, opening address, and delivery. Entitled Examination of Witnesses, we'll take a look at what is examination in chief, what is cross-examination, what is re-examination, what purpose do examinations serve in a trial, what questions are not allowed in examination in chief, admissibility of documentary evidence such as confessional statements, expert evidence, and police reports, admissibility of PSI evidence, the procedure for refreshing memory, and the procedure for dealing with hostile witnesses. Part of trial, that's part 4, presentation of the case for the defense. We will treat options available to an accused person at the close of the case for the prosecution, no case submission and when it is made, resting case on the prosecution's case, opening address for the defense, procedure for visit to a locus inco, application of the ex improviso rule, final addresses for the parties, in part 13, we will treat judgment and sentencing. The contents, the type, the form, and the delivery of judgments, the effect of failure to comply with Section 308 of the Administration of Criminal Justice Act, time limit to deliver judgment, the effect of failure to deliver within the time set by the Constitution. Conviction, allocutus, its desirability and perspectives. Sentence, the power of a court to take other offenses into consideration. Types of punishment, the death sentence, the form of pronouncing death sentence, the effect of failure to comply with the form, exceptions to death sentence, the prerogative of mercy, and restorative justice. Under the heading Appeals, we will consider the right of appeal, who can appeal, where to file appeals, time limit for appeals, type of appeal, constitution of the court to hear appeal, difference between appeal and case stated, appeal from magistrate courts to high courts, the time limit to file notice, the grounds upon which the prosecution may appeal, and the grounds upon which the accused may. We'll also look at bail pending review, the power of judicial review, appeal from High Court to the Court of Appeal, using subtopics such as when the appeal may lie as of right and when the appeal may lie with leave, notice, compilation of records, filing of briefs of arguments, hearing, orders that the court can make after hearing, appeal from the Court of Appeal to the Supreme Court, using such subtopics as when appeal may lie as of right, when appeal may lie with leave, notice, compilation of records, filing of briefs of argument, hearing, orders that the court can make after. Security to prosecute appeal, abatement of appeal, abandonment of appeal, effect of wrongful admission or rejection of evidence, mistrial or miscarriage of justice, circumstances under which a trial will be ordered by an appellate court.